All right, let's get some legal analysis now, joined by legal expert Zola Majavu, who is going to give us a bit of what we saw playing out there in that court. Mr. Majavu, good to have you, and thank you very much for your time. In your experience and your time on the bar, the first and foremost, how this has been constructed as a case and put together by Thabo Bester, did it stand any chance of actually getting a win?
Good evening, Thabo, and good evening to the viewers out there. Thanks for the opportunity. I think a good starting point would be to acknowledge that Mr. Bester, with all his shortcomings and whatever we may think of him as a convicted person, raised quite important issues. However, little knowledge also kills, because the essence of what he sought to convey to the court was lost in the manner in which he brought his application. That's the first thing. Secondly, I believe that he would have been better served had he retained one of his legal advisors who have been assisting him, even on the sidelines, because he brought this application firstly as an urgent application. Now, for it to be enjoying the attention of the court on the basis of urgency, he has to demonstrate that it is indeed urgent, that he will also not have any other substantial recourse in the future, and further that the balance of convenience favors him or the relief that he seeks. And I'm using these words very generally so that I don't lose the following of the viewers. So did he stand a chance to succeed? No. Any experienced lawyer would have told you that he would fail at the first hurdle, namely of urgency. The issues that he sought to raise, whether they have merit or not, are not issues that he suddenly woke up today or last night realizing that they need to be sorted out. So on the basis of urgency alone, it was a stillborn application. But in fairness to him, if one has regard to how this type of proceedings are conducted in our courts, especially in the North and South Gauteng divisions, it is mostly on what is called case online or case lines, which is a highly electronic process, which you cannot participate in unless you have the requisite gadgets. Bar minimum, you need at least a functional laptop together with a printer or a scanner to enable you to scan whatever documents that you need to put before the court and your opponents. Now, absent access to those, he would definitely not be in a position to avail himself to the rights and remedies that he is entitled to.
So he raises that point at the point of saying these things are urgent because I need then to be able to interact with this system that this honorable court is using, which is an electronic system, and for me to be able to access that, these are the devices and the kind of connectivity that I need. Does that fall within the urgency debate?
The agency is triggered by when did you first come to the realization that as Mdluli you are going to require these. And that is precisely where he fails, because it is not a new thing. But the substance of the issues that he is seeking to bring to the court, had he gone to court in the normal course, I suspect that he might have received a somewhat sympathetic hearing, even though on the merit side, the stakes are actually loaded against him, because the very gadgets that he seeks, as a matter of public record and on objective facts discernible from the papers, it's a fact that he used those gadgets previously to further commit crimes while he was already convicted and serving time. So it is not an objective fact that any court would have ignored. But in this instance, we didn't even get to that stage. He simply failed on agency. However, the respondents' representatives, meaning the legal representatives of the Department of Corrections, had already even canvassed the issue of the merits. And even on that score alone, had the court accepted that there was agency to this application, in my respectful view, he would have still failed on the substantive part when it comes to the merits. There is no way any court of law would have acceded to the kind of relief that he was seeking.
So now the purpose of the application, of course, being the matter that will sit in February, and there was this back and forth big debate whether or not he's got a constitutional right to a laptop and a modem, or he's got a right to the books of law that he needs to prepare for his particular matter. We didn't even get to that point of that argument, except the judge saying, look, I'm ruling that they give you the books that you need.
Yeah, and I think the judge was trying to strike a delicate balance to make sure that his constitutional rights are not violated. But remember, the judge was seized with an urgent application. And for an urgent application to enjoy the attention of a court, let alone the court ruling in your favor, you've got to satisfy the agency requirement, which he failed to do. But recognizing that he needs some form of access to whatever else that he requires to enable him to prepare for his defense for any forthcoming applications or hearings, the judge did rule that you can be given access to all the documents that you need. But what I think the public must not lose sight of is it is bringing to the fore quite sharply that we also need to advance with the developments of artificial intelligence, and the law itself must also adapt. Because the truth of the matter is, absent a computer and a modem and a printer and a scanner, it is not physically possible for him to fully participate in our judiciary to the extent that we are relying on case online. Yeah. That is of equal application to anyone. Even some of those old school lawyers who didn't have these gadgets, they have now been forced to invest in these gadgets, because that is also part of enhancing the efficiencies and making sure that judicial time and resources is used optimally against the difficulties that they have. But on the other hand, it means that if you, as Mdluli, do not have the wherewithal, you may find it very difficult to access the courts on the platform that the courts have itself set for itself. That does not mean, however, that you can be left without legal representation or some form of assistance. But this issue, having been raised by Mr. Bester, is going to be with us for quite some time.
So what's the remedy here? Because then, as we sit right now, the CMAX prison where he's being detained does not allow him to have access to these devices, printers and so on and so forth. So if it comes to a point where he's got to submit his heads of arguments, he's got to, whether there's responding affidavits or anything of that nature that he needs to do, how does he do that?
No, it's a fair point. That's why I'm saying at the heart of his argument, I can appreciate where he is coming from. He just lacked the necessary legal dexterity, and for his own sins, the judge, in fairness to the bench, afforded him an opportunity. And he kept on saying, I need an hour. The judge says, no, I need 2 hours at the most. And then at some point, there was even talk of this matter standing down until Thursday, so that the very practical challenges that he's complaining about could be attended to. And he insisted that he'll be ready at 2 o'clock, and the matter stood down for 2 o'clock. Where to from here? I think the Department of Corrections needs also to come to the party. They must not be blinded by his history and sacrifice his other rights at the altar of his bad behavior. He's been a bad boy, everybody knows that. But to the extent that for these other upcoming matters, he is presumed innocent, all his constitutional rights must be protected, and all practical steps must be taken to make sure that he has access to those facilities. And on the other side, we must also remember that the Department of Corrections was badly embarrassed as a result of his escape, his holding of parties using the very same gadgets. So there's got to be a delicate balancing act. I do not think it will be difficult or impossible for them to put up a desktop in some common area in the library where other students are accessing this, and make sure that for a limited basis, they monitor the sites that he may have access to, and to make sure that he at least complies with all the court requirements from a timeline point of view. Because remember, the court is going to treat him like any other litigant. The court is not going to say, oh, because you are Mr. Bester, you are kept in a cell for 23 hours, we have to ignore the rules. It doesn't work that way. But the Department of Corrections can and should be able to adequately accommodate him and others. I'm sure he's not the only one who's sitting with this problem. I think he's probably the only one who was brave enough to bring this to the matter, to the fore, even though he would have gone about it slightly the wrong way. But I don't blame him for a non-legally trained person. I think he's a smart fellow. He did reasonably well under the circumstances. But like I said, little knowledge also can become dangerous sometimes.
Mr. Majavu, appreciate your time. Legal expert there, Solomon Majavu, on that analysis.